Robert King walked into Detroit courtroom in 2012 expecting a fair hearing. What he didn't know was that the judge presiding over his case was sleeping with the mother of his child, texting her from the bench, having sex with her in his own chambers, giving her money, letting her whisper in his ear about how to rule. Robert King lost that case. Then he sued the judge, and the court told him, "The judge is immune. You can't touch him." This is the story of Judge Wade McCree, a man who used the most powerful seat in a courtroom to destroy an ordinary man's life, and walked away protected by the very system he corrupted. Welcome to Crime on Record, every case on record. Let's get into it. Wade McCree wasn't some backroom judge nobody had heard of. He was a rising star in Detroit's legal establishment, appointed to the 36th District Court in 2004, later elevated to Wayne County Circuit Court, one of the busiest and most powerful courts in Michigan. He earned a reputation as sharp, confident, and ambitious. He also came from royalty. His father, Wade Hampton McCree Jr., was the first African-American appointed to the U.S. Court of Appeals for the Sixth Circuit, later the second black Solicitor General in American history under President Jimmy Carter. The McCree name carried weight. Wade Jr. had every advantage: a prestigious family legacy, a powerful platform, a $140,000 annual salary, a wife of 25 years, and he threw all of it away, not in one moment of weakness, but in a slow, calculated series of decisions that revealed exactly who he was behind that black robe. It started with a photo. In 2010, Judge McCree snapped a shirtless photo of himself on his cell phone and sent it to multiple people who worked in or around his courtroom. The caption read, "2010 Dexter Ann Arbor race, fit in my 50s. One recipient, a married female deputy sheriff named LaDawn Malone, kept the photo. Her husband found it in 2011 and filed complaints with the Wayne County prosecutor and the Michigan Judicial Tenure Commission. When a local Fox News reporter named Charlie LaDuff confronted McCree about the photo, McCree's response told you everything you needed to know about this man. "Hot dog. Yep, that's me. I've got no shame in my game. Ain't talked to nobody else's wife. There's nothing nude about it. I'm in no more clothes than I'll be at the Y this afternoon when I swim my mile." Then he pretended to take his shirt off for the camera. The Michigan Supreme Court censured him for the incident, a formal public reprimand, a slap on the wrist. McCree took that censure and kept moving. But instead of cleaning up his act while under investigation, he did something far worse. To understand why Robert King never got justice, you first need to understand a doctrine that most Americans have never heard of, but that affects every single person who has ever walked into a courtroom: judicial immunity. The idea is simple on its face. Judges need to make difficult decisions every day. They rule against people. They send people to prison. They terminate parental rights. They award custody to one parent over another. If every losing party could turn around and sue the judge personally, no judge could function. Every ruling would be second-guessed in a separate lawsuit. The entire justice system would grind to a halt. That is the argument for judicial immunity, and on its surface, it is not an unreasonable one. The problem is how far it extends. The United States Supreme Court formally adopted judicial immunity in 1871 in a case called Bradley v. Fisher. The ruling established that judges cannot be sued for actions taken in their judicial capacity, even if those actions were wrong, biased, or malicious. Read that again. Even if those actions were wrong, biased, or malicious. The court's reasoning was that the threat of personal liability would compromise judicial independence. A judge who fears being sued might rule differently, not based on the law, but based on self-protection. So the Supreme Court decided that the integrity of the system required judges to act without that fear. What the court did not fully anticipate in 1871 was a judge like Wade McCree, a judge who would use that immunity not as a shield for honest mistakes, but as a license for deliberate corruption. Over the 150 years since Bradley versus Fisher, courts have repeatedly been asked to draw a line. How corrupt does a judge have to be before immunity no longer applies? The answer, case after case, has been the same. There is almost no line. Judges have been granted immunity for ordering illegal arrest, for deliberately falsifying court records, for conducting hearings without jurisdiction. In one extreme case, a judge instructed police officers to physically rough up a defense attorney who failed to appear for a scheduled hearing. The Supreme Court held that judge immune from the resulting lawsuit. The only exception courts have carved out is for actions that are entirely outside a judge's judicial function, something completely unrelated to their role as a judge. McCree's attorneys argued successfully that his rulings in King's case, however corrupt they may have been, were still judicial acts. He was still sitting on the bench. He was still issuing orders in his capacity as a judge. The fact that those orders were influenced by his affair with the opposing party was, according to the courts, irrelevant to the question of immunity. Robert King's attorney Joel Sklar called it exactly what it was. McCree used judicial immunity as a shield for self-interest, and the law allowed it. This is not a story about one bad judge. It is a story about a legal doctrine that was designed to protect the integrity of justice, and that in this case was used to protect its destruction. In 2012, a woman named Geniene Mott walked into Judge Wade McCree's courtroom. She was there for a child support hearing. She wanted Robert King, the father of her child, to pay back child support. King owed $15,000 in arrears. McCree presided over the case, and somewhere between the gavel and the verdict, something happened that should never happen in any courtroom in the world. The judge and the plaintiff started an affair. According to the Michigan Judicial Tenure Commission's own complaint, McCree didn't just have a passing flirtation with Mott. He conducted a full-scale relationship with her while he was still deciding her case against Robert King. The details that came out in the disciplinary hearings were jaw-dropping. McCree had sex with Mott multiple times inside his own judicial chambers, not after work, not off courthouse property, inside the building where he held the power of law over Robert King's life. He gave her a private entrance. She didn't have to come through the public doors like everyone else. McCree arranged for her to enter through the courthouse's rear, private entrance, the door reserved for judges, and used the judicial parking lot. During one court session, McCree arranged for a sheriff's deputy to deliver Mott's phone to her inside the courtroom so she could call him while proceedings were ongoing. He texted her from the bench while presiding over other cases. Other people's lives were being decided, and he was texting his mistress. He gave her cash, approximately $6,000 across the course of their relationship. When she needed money, she'd reach out. McCree would provide. But here is where the story crosses from scandal into something far darker. McCree was letting Mott influence his rulings. According to testimony, McCree accepted her suggestions on how to handle King's case. The man he was supposed to be judging fairly was being discussed in text messages and pillow talk between the judge and the opposing party. Robert King was ordered to pay child support. He was also ordered to wear a tether, an electronic monitoring device typically reserved for criminal defendants or flight risks. King was neither. He was the respondent in a civil child support case, but McCree ordered the tether anyway. King alleged in his later lawsuit that McCree ordered unfairly high child support payments and imposed the tether specifically to please Mott, to punish the man his mistress wanted punished. McCree also presided over a separate case involving a man named Tillman, who happened to be a relative of Mott's. McCree reduced Tillman's bond in that case, a favor for his mistress's family, administered from the bench, and then Mott became pregnant. When the affair started to cool, McCree turned on Mott completely. He filed a criminal complaint against her, alleging she was stalking him and extorting him by demanding $10,000 in exchange for getting an abortion and staying quiet about the pregnancy. He tried to use the criminal justice system to silence the woman he had just finished impregnating in his own chambers. The complaint went nowhere, but by this point the affair was fully exposed. The Judicial Tenure Commission launched a full misconduct investigation. McCree was suspended without pay. In almost every retelling of the Wade McCree story, the focus lands on two people: McCree, the corrupt judge, Robert King, the man whose case was rigged against him. But there is a third person in this story who rarely gets examined with any depth: Geniene Mott. It is easy and perhaps tempting to view Mott simply as a willing participant in the affair. She was an adult. She made choices, and the coverage on this case, particularly in its early stages, often treated her that way, as a footnote, or worse, as the cause of McCree's downfall, rather than someone who was herself caught in a situation shaped by a profound imbalance of power. Consider the circumstances of how this relationship began. Mott did not meet McCree at a social event. She did not seek him out. She walked into his courtroom as a plaintiff, a woman trying to get child support for her child. She was in a vulnerable position, dependent on the outcome of a legal proceeding, facing a judge who held complete authority over her case, and that judge initiated a relationship with her. The power differential here cannot be overstated. This was not two equals deciding to pursue a connection. This was a man in a black robe, with the authority to rule in her favor or against her, to help or hurt her financially, to make her life easier or harder with the stroke of a pen, who began pursuing a romantic relationship with a woman whose fate he controlled. Did Mott make choices that were questionable? Yes. Did she discuss King's case with McCree in ways she should not have? The testimony suggests she did. Did she at times use the relationship transactionally, accepting money, accepting favors? The record suggests all of this is true, but none of it changes the fundamental dynamic. A judge pursued a plaintiff in his own courtroom. That is on him. The ethical obligation, the legal obligation to maintain the integrity of that proceeding rested entirely with Wade McCree, not with Geniene Mott. And when the affair ended, when McCree decided he was done, he did not simply walk away. He filed a criminal complaint against her. He alleged she was stalking him, that she was extorting him, that she was demanding $10,000 to get an abortion and stay quiet. Think about what that means. A sitting judge, with all the credibility and institutional power that title carries, filed a criminal complaint against the woman he had been sleeping with in his own chambers. He attempted to weaponize the criminal justice system against her, the same system he was sworn to administer fairly. The complaint went nowhere, but the message it sent was unmistakable. McCree was willing to use every tool available to him: his robes, his chambers, his access to the criminal complaint process, in service of his own interests. Geniene Mott was not a villain in this story. She was a woman who entered a courtroom seeking help for her child, found herself in a relationship with the most powerful person in that room, and when it ended, found herself on the receiving end of a criminal complaint filed by a judge. In the media coverage of the McCree scandal, her name appeared mostly in connection with the salacious details of the affair. The deeper question, what does it mean when a judge pursues a plaintiff in his own court, was rarely asked. It should have been the first question anyone asked. Robert Kings did not choose to be part of a landmark judicial misconduct case. He did not set out to test the limits of judicial immunity doctrine. He walked into a courtroom because he owed child support. That is it, a civil matter. The kind of case that goes through family courts across America every single day. He owed $15,000 in arrears. That is not nothing, but it is also not unusual. Family court dockets are filled with cases exactly like his. What happened to Robert King in that courtroom was not the result of a judge carefully weighing the evidence and reaching an unfavorable conclusion. It was the result of a judge who was sleeping with the opposing party, taking her suggestions about how to rule, and issuing orders designed to please his mistress rather than reflect the law. King was ordered to pay child support. He was also ordered to wear a tether. Let that sink in for a moment. A tether is an electronic monitoring device. It tracks your location at all times. It restricts where you can go and when. It is a physical object attached to your body that announces to everyone around you, your employer, your family, your neighbors, that the court does not trust you. Tethers are typically reserved for people who pose a flight risk, for criminal defendants awaiting trial, for people the court has specific documented reasons to believe will not comply with its orders without physical surveillance. Robert King was none of those things. He was a man in a civil child support proceeding. There is no public record suggesting he had threatened to flee, refused to comply with prior orders, or given the court any legitimate reason to impose electronic monitoring. But McCree ordered it anyway, because Mott wanted him punished, and McCree was willing to use the full authority of his judicial office to deliver that punishment. Think about what wearing that tether meant for King's daily life. His ability to work, his ability to move freely, the conversations he had to have with people who saw it, the assumptions people made, the doors that closed, and then think about the child support payments, ordered at a level King alleged was inflated beyond what the law required. Month after month, money leaving his pocket, not because a fair judge calculated what was appropriate, but because a corrupt judge was trying to impress his mistress. King fought back the only way available to him. He sued. He spent years in the legal system, first in federal district court, then in the Sixth Circuit Court of Appeals, then petitioning the United States Supreme Court. He paid lawyers. He invested time. He carried the emotional weight of fighting an institution that had already wronged him once and continued to rule against him at every turn. At the end of all of it, he had nothing to show for it financially, no damages, no compensation, no acknowledgement from any court that what happened to him deserved to be made right in any material sense. The Michigan Supreme Court removed McCree from office. That was the system's answer to Robert King. Not your money back, not compensation for the tether, not recognition that you were subjected to a rigged proceeding and deserved to be made whole. Just, the judge lost his job for a while. Robert King's story does not end with a dramatic courtroom vindication. It does not end with a check. It does not end with a moment where the system looks him in the eye and says, "We failed you, and here's what we are going to do about it." It ends with the Supreme Court that declined to even hear his case, and a legal doctrine, unchanged since 1871, that remains in place today, ready to protect the next Wade McCree the same way it protected this one. Wade McCree was not an anomaly. That is perhaps the most disturbing thing about this entire case. Wayne County, the Michigan county that encompasses Detroit, has a documented history of judicial misconduct that stretches well beyond one shirtless judge with a mistress in his chambers. McCree's case drew national attention because of its lurid details: the sexting, the affair, the pregnancy, the criminal complaint. These were the kind of fact that travel across the internet and land on cable news desks. But behind the headlines was a deeper institutional problem that the coverage rarely examined. Wayne County Circuit Court handles some of the most consequential cases in Michigan: criminal trials, child custody battles, civil disputes involving millions of dollars. The judges who sit on that bench wield enormous power over ordinary people's lives. People who in most cases have no realistic ability to challenge a ruling they believe was unfair, and the oversight mechanisms designed to keep those judges accountable have repeatedly proven inadequate. The Michigan Judicial Tenure Commission, the body that investigated McCree, operates largely in secrecy. Its proceedings are not public. Its deliberations are not transparent. By the time misconduct becomes visible to the public, it has typically already been happening for years. McCree's shirtless photo scandal began in 2010. His affair with Mott began in 2012. The full extent of his misconduct did not become public until disciplinary hearings in 2013 and 2014. 4 years of documented inappropriate behavior before any meaningful consequence landed. And even then, the consequence was removal from office, not criminal charges, not civil liability, not any form of accountability that required McCree to compensate the people his conduct harmed. This is not unique to Wayne County. Across the United States, judicial discipline is handled almost entirely within the legal profession itself. Judges are investigated by commissions staffed largely by lawyers and other judges. The proceedings are typically confidential. The sanctions available are limited: censure, suspension, removal. And as Robert King's case demonstrated, even removal does not open the door to civil accountability. The result is a system in which judges operate with a level of insulation from consequences that would be unacceptable in almost any other profession. A doctor who commits malpractice can be sued. A contractor who does shoddy work can be sued. A financial advisor who gives corrupt advice can be sued. A judge who conducts an affair with a litigant, lets that litigant influence his rulings, orders punitive measures against the opposing party to please his mistress, impregnates her in his own chambers, and then files a retaliatory criminal complaint against her, cannot be sued. The Wayne County story and the broader American story it represents is not just about Wade McCree. It is about what happens when a system designed to deliver justice becomes more focused on protecting its own than on protecting the people it was built to serve. Robert King walked into that courtroom in 2012 believing in the system. He had no reason not to. He had no way of knowing that the man in the black robe looking down at him had already decided whose side he was on. That is not a failure of one corrupt judge. That is a failure of every safeguard that was supposed to prevent exactly this from happening. The Michigan Supreme Court took the matter seriously to a point. In March 2014, after a full disciplinary hearing, the Michigan Supreme Court removed Wade McCree from office, banned him from serving as a judge for 6 years, assessed $12,000 in costs against him, found that his conduct was prejudicial to the actual administration of justice. The court's language was unambiguous. McCree had harmed not just the parties in front of him, but the integrity of the entire judicial system. For the legal establishment, that was justice served, a judge removed, sanctions imposed, the system worked. Robert King saw it differently. King filed a federal civil rights lawsuit against McCree. His argument was simple and devastating. He never had a fair judge. His constitutional right to due process was violated. The man deciding his case was sleeping with the opposing party, taking her suggestions and ruling in her favor. King wanted damages. He wanted accountability in a form that actually cost McCree something. The U.S. District Court in Detroit dismissed the case. Judicial immunity. King appealed to the Sixth Circuit Court of Appeals. In July 2014, a 3-judge federal panel upheld the dismissal. Their ruling called McCree's behavior often reprehensible. But reprehensible didn't matter. The doctrine of judicial immunity, a legal protection rooted in an 1871 Supreme Court case, shields judges from civil lawsuits for their judicial acts, even corrupt ones, even malicious ones. The court wrote that under existing Supreme Court law, Judge McCree is immune from suit under the doctrine of judicial immunity. One judge on the panel, Guy Cole, wrote separately. He wanted the record to be clear. The court was not endorsing McCree. It was constrained by precedent. He called the outcome the best justice possible under existing law, meaning it wasn't much justice at all. King's attorney Joel Sklar refused to accept it. There should be no immunity for what happened here, he said. This conduct is absurd. He petitioned the U.S. Supreme Court to take the case. In January 2015, the Supreme Court placed it on preliminary review. McCree's attorney, Brian Einhorn, dismissed the effort. "I think he's wasting his time," Einhorn said. The Supreme Court declined to hear the case. Robert King had exhausted every legal option available to him, every court, every appeal. The answer was the same. The judge who rigged the case against you cannot be sued for rigging the case against you. Wade McCree served out his removal. His 6-year ban expired in 2020, meaning he became legally eligible to return to the bench. There is no public record of him returning to judicial office. Robert King never received a dime in damages. The tether he was ordered to wear, the inflated child support payments, the rulings made against him by a judge who was simultaneously sleeping with his child's mother. None of it was compensated. None of it was reversed in a way that acknowledged the fundamental injustice of what happened to him. The doctrine of judicial immunity, established in 1871, remains the law of the United States today. A judge can conduct an affair with a litigant, rule against the opposing party, impregnate the plaintiff, file a retaliatory criminal complaint against her, and walk away from a civil lawsuit without paying a single dollar. That is not a hypothetical. That is exactly what happened. What makes the McCree case uniquely infuriating is not just the misconduct, it is the legacy. Wade McCree Jr. came from a family that fought for justice in America at the highest levels. His father broke racial barriers in the federal judiciary. He served under a president committed to civil rights. His son used the power that legacy helped build to exploit a vulnerable woman, corrupt a child support proceeding, and abuse the constitutional rights of an ordinary man who had no idea what was happening to him. And the system that was supposed to hold him accountable decided that protecting judges from lawsuits was more important than protecting citizens from corrupt judges. The Wade McCree case raises a question that nobody in the legal establishment wants to answer directly. If a judge can do everything McCree did and still be shielded by judicial immunity, what exactly does it take for a citizen to get justice against a corrupt judge? The answer, based on this case, is removal from office. That is it. No damages, no compensation for the person whose life was disrupted, no financial accountability. Robert King spent years fighting through every court in the American system. He lost every time, not because he was wrong, because the law said the judge's protection matters more than his rights. That is the record. If you found this case as outrageous as we did, subscribe to Crime on Record. We cover the cases that expose how the system actually works, not how it is supposed to work. New cases every week. Next week, we are covering a case where an entire sheriff's department was running the operation they were supposed to be investigating. That story is coming. Every case on record.